the jail hear me?
We're okay here.
Okay. All right, all set? Everybody okay? All right, good morning, everyone. My name is Judge Ashley Kilbane. I'll be holding this arraignment today. I need to read you some instructions. Please pay attention because these are important instructions for your arraignment and also your constitutional rights. You are not here for the trial of your case. You are here for your arraignment. An arraignment is an opportunity to be informed of the charges against you, for bond to be set, and for you to enter your plea. You do not have to make any statement about the charges against you, but be advised that any statement that you may make may be used against you. As your name is called, you'll be asked to step forward. You'll be asked when you received a copy of your indictment or information and whether or not you understand the charges against you. By law, you have 24 hours before you must respond to the indictment or information. If it has been less than 24 hours since you received a copy of your indictment or information, but you wish to be arraigned anyway, you may waive the 24-hour notice and we will complete your arraignment this morning. If your case is going, are there any informations today? Are there any informations today? All right. You'll be asked how you plead. A defendant may plead not guilty by reason of insanity, guilty, or with the consent of the court, no contest. If you want to plead guilty and you do not have an attorney, the court will assign counsel for you so you may have a full understanding of your constitutional rights. Your case will be assigned to a judge whether you plead guilty or not guilty. If you refuse to plead, the court will enter a not guilty plea on your behalf. If you have been charged with a crime of violence and/or any drug offense, under Ohio law, you cannot knowingly have, carry, or use a firearm or dangerous weapon until your case is concluded. This is called being under a disability. If you violate this disability, you could be charged with a separate felony offense in addition to the original charges for which you are being arraigned for today. Even if you have a carry concealed weapon permit, you are still under a disability until your case is over. In fact, upon indictment, the sheriff who issued the permit shall suspend it until your case is over. Finally, if you are over 18 and have not provided a DNA specimen since 2011, you may be required to submit one within 24 hours of your arraignment. I'm going to explain to you your constitutional rights. Please listen carefully. The Constitution of the United States and the state of Ohio. Persons charged with commission of an offense are guaranteed certain basic rights. They are the right to know and understand the charges against you, the right to a speedy trial, the right to a trial by a jury. You may waive or give up that right and have your case tried by a judge without a jury. At trial, the state of Ohio has the burden to prove you guilty by evidence beyond a reasonable doubt. You have the right to meet your accusers face to face and to cross-examine the witnesses for the prosecution. You have the right to summon, subpoena, or demand that witnesses appear on your behalf. You do not have to testify against yourself. You have the right to counsel. If you are unable to afford an attorney, the court will appoint a lawyer to defend you. You will be assessed a $25 fee for an appointed attorney. You will not be denied an attorney if you are unable to pay this fee. At the end of the case, you may be ordered to pay the assigned counsel fees if your judge determines you are financially able. If you choose to hire your own attorney, you have the right to a reasonable continuance to hire one. Okay. Call the first case.
We'll start with a jail case number 682899, co-defendant A, Jaylon Jennings.
Thank you. Good morning, Your Honor. Chuck is over with the Public Defender's Office. I will acknowledge the indictment, waive the pending reading, advisement, and notice, and enter a not guilty plea. Ask that he receive assigned counsel and reasonable bond.
Okay. The not guilty plea will be entered. The bond was previously set at $9 million, cash surety property, no contact with the victim, with court supervised released, GPS standard. I will advise that he does have a warrant out of Lorain County. Any other comment on bond?
You're maintaining the state requested $9 million bond?
Yes.
Thank you, Your Honor.
Okay, so that will be continued. Assigned counsel, I will assign Fernando Mack to represent you, Mr. Jennings. You're going to be on the docket of Judge Jennifer O'Donnell. Your next court date is August 7th at 9 a.m. Thank you. Is that all you guys were here for? Okay. That's it? Oh, he has another one? Oh, okay. Are you guys here for somebody else?
Yes.
He's, okay. It'll be a while, I think. I don't think he's available. Mr. Jennings is done. Yeah.
Another jail, case number 683048, co-defendant B, Darnell Olds. Retained counsel present. This is a re-indictment going back to the docket